Well, there you've just heard the High Court in Pretoria has ruled today that a medical doctor cannot be prosecuted if he assists a patient requesting to die. Robin Stransham-Ford asked the court to rule that a doctor who accedes to a patient's request to be assisted to end his or her life is guilty of no wrongdoing. He argues that not being able to do so and spending his last days in pain and suffering infringes on his constitutional right to dignity. Stransham-Ford is suffering from terminal prostate cancer. Well, for more on that, we're joined on the line by our legal analyst, that's Clifford Gordon from CL Gordon Attorneys. Good afternoon, Mr. Gordon, and thank you for your time on the PM News Desk.
Good afternoon, and thank you for your call.
Cliff, a precedent-setting case here. How significant a judgment is this, and what are some of the legal implications on the medical fraternity especially?
Well, in this particular case, it means that if somebody is terminally ill, they can apply to court and have their life ended by a doctor. Also, I don't know if it necessarily sets a precedent for anyone but the applicant in this matter, because he himself, and he went and he applied only for himself. They didn't have an implication for anybody else other than the applicant, as I said. And the implications on the medical fraternity would be that if they assisted this particular applicant in his bid to die with dignity, then they wouldn't be prosecuted. But maybe if they assisted somebody else who hadn't applied for permission or court application, they might be prosecuted and charged with murder or similar.
I see. Well, Stransham-Ford's main argument here was that he has a constitutional right to dignity, like we all do, while the state was saying that the Constitution also includes the right to life, and therefore assisted suicide is unconstitutional. So it's almost like being caught between a rock and a hard place, Cliff.
Well, the Constitution always has allowed for balancing of rights and for limitations of rights. So what a court would have to consider, and what the court did consider, is a person's right to life in a way that wasn't necessarily a good life. So in Mr. Ford's case, he has literally weeks to live, and he will die a possible painful death. And then, so in other words, he wouldn't have a very good quality of life, and it wouldn't be dignified. Although that is in his case. In someone else's case, it might be different, in that the right to life would outweigh the right to dignity. So it would have to be decided on a case-by-case basis. Yeah, that's basically how it would work.
Cliff, as such cases become more and more public, there are more and more ethical arguments that become steeped in controversy. It does speak to a need for more decisive action on laws on the issue, because even if the judgment is in, as it is today, there still remains complex issues around euthanasia and assisted suicide. In this particular case, in the absence of any law on the matter, the judge was legally obliged to rule on the case and the man's rights.
Definitely. Without legislation saying that in which circumstances assisted suicide or so-called euthanasia or similar actions can take place, and in what circumstances. Also, there needs to be other considerations. For example, what happens in the case of someone who's on life support and cannot make a decision for themselves? And so yeah, it's extremely complex. But as I said, the judge had to, or as you said, should I say, the judge had to make a ruling on the case in front of him. There couldn't have been, the judge couldn't have avoided making a ruling. Or in this case, he had to decide, and he made the decision in favour of the applicant in this case. But in another case, it might be different. Right. But then, as you said, legislation is sorely needed to make it make it very
Yes.
clear in which
Yes,
circumstances somebody
Cliff,
can
Cliff,
apply
you just heard from the insert that played out before. The NPA and Doctors for Life are not going to take this sitting down. They're going to appeal. How likely is such an appeal to succeed in our courts?
Well, one problem is that the applicant could be dead by the time the appeal is brought. It is very possible that the appeal could succeed, that another court would make a different decision. For example, a full bench or the Supreme Court of Appeal could very well say no, the judge was wrong here, that the right to life is all encompassing, and the right to dignity certainly doesn't trump the right to life. So therefore the ruling was incorrect.
Thank you, Clifford. I'm afraid we'll have to leave it there. We are out of time. Clifford Gordon from CL Gordon Attorneys.